There are two issues arising from these facts. The first issue is whether Rydal does have standing as challenged by agents for the applicant, and the second issue is whether there has been a violation of Article 6 of the treaty, which prohibits direct and indirect expropriations unless certain conditions have been met. So on the first issue of standing, we've heard submissions by agents for the applicant that Rydal lacks standing both on the basis of nationality and also exhaustion of local remedies. So turning to this first issue of nationality, it is Rydal's submission here that it can bring a claim on behalf of either ALEC or Rocco. So first in relation to ALEC, and what we have heard from agents for the applicant is that ALEC is an expatriate national based on the test set down by this court in the Barcelona Traction decision of 1970, where the court held that the customary test for corporate nationality is the place of incorporation. However, Rydal seeks to rely here on an exception to this test, which was left open by this court in its Barcelona Traction decision and again by this court in the Diallo decision of 2007, and that is the exception of the principle of substitution as is contained in Article 11B of the International Law Commission's draft articles on diplomatic protection.
Do the Rydalian shareholders qualify for protection under the BIT's definition of investment?
Yes, Your Excellency. In the alternative that our substitution exception is not accepted by this court, we do submit that we can bring a claim on behalf of Rocco independently, that Rocco is an investor
Which is your stronger argument?
The first in relation to ALEC, Your Excellency, as we can bring a claim on behalf of the company rather than the shareholders, Rocco, who only holds 80% of the shares, so harm would be less there. So in relation to this first argument concerning ALEC and the principle of substitution, Your Excellencies, this exception applies where the state of incorporation is itself the injuring state and further has required incorporation as a precondition for that company doing business in the state.
If you read Diallo as a whole, do you sense any reluctance to affirm the Barcelona exception in today's world?
Your Excellencies, in Diallo we do concede that the court rejected the broad principle of substitution. However, they left open this more narrow principle as is contained in Article 11B, as that article was not particularly relevant on the facts of that case. So we would submit that there was no reluctance in the Diallo decision, rather the court was neutral on its application.
Could that have been because it didn't wish to tread on the toes of the ILC?
Perhaps, Your Excellency. But we do submit that this exception is applicable here because when we have the situation where substitution arises, there is a vacuum created in diplomatic protection as there is no state to bring a claim on behalf of the company. So in such a case, the nationality of the company's primary shareholders can be substituted for that of the company, meaning that the company would then be a foreign national. It is our submission that such an exception does apply.
I don't understand this gap argument. Why does every company have to have a state that can represent it? We now have investor-state arbitration. The company could just figure out some way to take the case itself.
In this case, Your Excellency, both states are not parties to the International Centre for the Settlement of Investment Disputes Convention, which we do concede does provide for mixed arbitrations in that investors have a direct right to bring a claim against a state. This bilateral investment treaty is unique in that Article 13 does provide only for claims of diplomatic protection. So therefore we do need this principle of substitution to bring a claim on behalf of ALEC, as here ALEC would have no recourse to any other international mechanism to resolve its dispute and the harm it suffered at the hands of Espatria. So this exception does apply here, Your Excellencies, as by virtue of the Natural Resources Act passed in Espatria in 1991, ALEC was required to incorporate in Espatria, and indeed Rocco was forced to channel all of its Espatrian business through ALEC after the passage of the Natural Resources Act. We would finally submit that this principle of substitution is an exception recognised at customary international law. The International Law Commission, particularly the Special Rapporteur Jean Dugard, stated in the commentary to the draft articles that he found that Article 11B was to represent a codification of customary international law, which was represented by both state practice and opinio juris supporting its application in customary international law.
Well, some governments have expressed concern that this bilateral investment issue, which is all set forth in positive law, is now being generalized as customary international law, when in fact many bilateral investment treaties can have slightly different provisions. Shouldn't the positive law control over these? I mean, John Dugard is a lovely man, but do we really want him stating all the rules? What's the point of negotiating a treaty's terms carefully if John Dugard's view is trumping over that of sovereign states?
Your Excellencies, the majority of states actually would favour a broader test in their bilateral investment treaties, particularly the United States, as a large capital exporting state, has a much broader test within their 2004 Model Bilateral Investment Treaty, providing shareholders with much more rights to be able to bring claims. However, this principle of substitution we would submit is founded in state practice, that there have been a number of states who have both bought and accepted claims on the basis of substitution, notably the United States, United Kingdom, Guinea, Mexico and Portugal. And further, there are a number of states who made submissions to the International Law Commission stating that they did support this principle of substitution, and therefore we submit that we do have the requisite state practice and opinio juris outside of what has been concluded in bilateral investment treaties to show that this exception is founded in custom. But as I noted earlier, if the court does not accept this submission, we do have an alternative submission that we can bring a claim independently on behalf of Rocco. That Rocco is an investor under the bilateral investment treaty by virtue of the shares that it holds in ALEC, as shares and equity participation are an investment defined in paragraph B of the definition of investment. We've heard from agents for the applicant that shareholders can only bring a claim when their direct rights have been affected. However, it is our submission that that is only the position at customary international law and diplomatic protection when a treaty does not provide otherwise. Here, the bilateral investment treaty does follow the practice of states who seek to avoid this strict rule in Barcelona Traction, and in the decisions, the NAFTA decision of GAMI and Mexico in 2004 and Saluka and Czech Republic in 2006, shareholders who were investors under a bilateral investment treaty were allowed to bring a claim for the drop or the decline in the value of their shareholding as a result of actions taken against the company.
In the time you have left, don't you want to make a case that past standing there's actually a expropriation? Or... Of
course, Your Excellency. And I would note here that we do have submissions on local remedies, but I would refer the court to our written memorials there. So moving to expropriation, assuming that Rydell does have standing, we would submit that there has been a violation of Article 6A of the Bilateral Investment Treaty, which prohibits both direct and indirect expropriation unless certain conditions have been met. One of these conditions is the payment of prompt, adequate and effective compensation. Aspatria has failed to do this, so if the court finds there has been an expropriation, there will be a violation of Article 6A of the treaty. So moving to this issue, Rydell submits that there has been an indirect expropriation of either ALEC's Aspatrian licence or the value of Rocco's shareholding. The test for whether there has been an indirect expropriation, as set out in the decisions of the Iran-US Claims Tribunal, is whether there has been a substantial deprivation of the rights of the investor. The factors which tribunals look at are the economic impact of a measure and also its duration. Here we submit that there has been a substantial deprivation of the rights of ALEC or Rocco, as all of the assets of ALEC have been seized within the territory of Aspatria, meaning they have been unable to do any business whatsoever, rendering their Aspatrian licence effectively useless.